Hi, my name is Liz Perloff, and in today's video I take you through the steps that I took to try and resolve this complaint before it went to court. Anybody who's been involved in the NHS complaints process knows it's a hard slog. The NHS refuses to take accountability, and as a result, improvements in medical imaging and differentiating between the symptoms of tendinopathy and osteoarthritis are not their priorities. Recap: in 2011 and 2012, Barnsley Hospital didn't diagnose a second joint dislocation and wrongly reported the fibular bone as healed. Based on the wrong diagnosis, they wrongly decided that the restricted movement was due to osteoarthritis and told me to keep on walking. The treatment plan to keep on walking was the worst possible treatment plan ever, as it was actually tendon damage, and me continuing to walk made the tendon damage worse. I asked Barnsley Hospital to investigate and apologise. They refused. For those of you who think the Duty of Candour is a mythical beast like a unicorn, it's not. It's actually health and safety legislation that if the NHS makes a mistake, they must apologise and put things right. Next on my list of complaints was the orthopaedic department at Sheffield Teaching Hospital. I pointed out that they'd failed to report their fibula as unhealed. Guess what? Sheffield Teaching Hospital didn't think they'd done anything wrong, and they didn't think the duty of candour applied to them. The story continues. Misdiagnosis after misdiagnosis. In 2015, Newham University Hospital took a hip x-ray and reported it as osteoarthritis. In 2020, there was no hip osteoarthritis in an x-ray. Newham University Hospital, part of the Barts NHS Trust Group, didn't think that the duty of candour applied to them, so refused to apologise or improve standards. The Hospotal Hospital also has a problem with correct reporting of medical imaging such as x-rays and CT scans. Obviously, they don't think it's a problem. They don't think the duty of candour legislation applies to them, and so didn't use it. Of course, the denial from the NHS, Hospotal and Newham University Hospital doesn't come cheap. I worked out that in the 3 years I complained, it cost them £23,500 to refuse to discharge their legal obligations under the duty of candour to me. My next move was onto University College London Hospital, who dithered and ummed and ahed about whether the fibula was or was not malunited. In 2018, they had to agree with me that it was malunited. But getting onto a little bit like Shaggy's, it wasn't me, you've got it right, they didn't do anything wrong, the duty of candour didn't apply to University College London Hospital either. Along the way, I complained to NHS England, I complained to the CQC, I complained to the Parliamentary and Health Service Ombudsman, saying, please investigate these complaints. We need to improve the standards of medical imaging so nobody else ever suffers from the constant pain that I do, which was totally avoidable. You're never going to believe it. NHS England, the Care Quality Commission, who are the Regulator for Healthcare Standards, and the Parliamentary and Health Service Ombudsman, who are the last port of justice for people of medical negligence, didn't think the duty of candour applied to them either. Eventually, I had no place to go. All complaint avenues had been shut down to me, so I turned to the courts. Judge Roberts just repeated the behaviour that I had from all the NHS, all the health regulators, all the health ombudsmen, and refused to hear my application to exclude the lies of the surgeon Paul Cooke. I didn't want to hear my application because then he would have actually had to deal with the fact that a doctor who's regulated by the GMC had lied to the court. By Judge Roberts refusing to hear my application to exclude the lies of the surgeon Paul Cooke, what he actually said to large law firms like DSE Beechcraft is that it's fine if you and your medical experts lie to the court, because I'm going to come down on your side. So he dismissed my claim, and he awarded, or should I say rewarded, the lies of DSE Beechcraft and the surgeon Paul Cooke £70,000. I have appealed because this is an outrageous abuse of my right to a fair hearing. Plus, it's not going to improve medical imaging standards in the UK, which is desperately, desperately needed. As part of the appeal process, you need a transcript, which is a written record of the hearing. The court has twice refused to give me a transcript for free, and they have invited me to pay for it. A transcript costs approximately £1.50 per 72 words. An average person speaks 150 words per minute. I cannot afford this, therefore I am being denied an appeal. If you think justice is not an auction, like a work of art to be bought and sold to the highest bidder, that justice is a right for all and it should be free, please donate to my cause, which is I am going to protest outside the Royal Courts of Justice in London, and I'm crowdfunding for accommodation costs so I can stay close by and see this protest through for as long as it takes. Thank you so much.